Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. We cover domain disputes. Basically, we got a new, tight, strict format. We go 30 minutes. We review 3 UDRP decisions. That's a domain dispute. We might do something else sometimes, but today we're going to review 3 cases and we're going to get out of here on time because it's better on the replay. It's better on David as well, but it's better on the replay. You can listen for 30 minutes and get your fill of domain name law. I guess I am already live streaming on YouTube. Let me check my co-host Mike. Hey David, how's everything going?
It's going well.
Fantastic. Let me get Jeff up here. It'll test his mic. But yeah, it's much easier on the replay when someone knows, okay, so I'm going to be listening to 30 minutes. Try to spend about 10 minutes on each decision. Some may be longer, shorter. But let's check Jeff's mic. Hi, Jeff. How's everything going?
Everything is going well. Deep into ICANN new GTLD applications. So fun is just getting underway again.
Yeah, it's going to be exciting too, after this window closes and then that reveal date sometime in October. But yeah, so thanks for joining us. I know you're busy. um, all right, we're going to jump right into it. Like I said, we got 3 decisions today, 3 UDRP decisions that we're going to take a look at. The first one is omis.com. So that is the domain that's being disputed, omis.com, a 4-letter. The complainant in this case is OMIS Group. It's an Italian company, been around a long time. They operate, and I'm going to mention what these companies who are the complainants in 3 cases today, what they operate on. This one operates on the omis.net domain name, so you can imagine, as us domain investors and also business people, we know is you'd like to have the .com if you're on the .net, and you'd like to know is it available and reasonably attainable. But so this Italian company that makes, um, they make like hoist lifting equipment, but it sounds like big industrial stuff. They've been around since 1967. They they filed the case against a company OMI apostrophe S OMIS. It's like they have, I guess, trademarks for clothing and food and all sorts of different things. But anyway, this complainant wanted the domain omis.com, reached out to this potential seller, especially after they found out that this owner they thought was the owner of the domain name had went out of business, and it looked like it was a bankruptcy filing, maybe an auction. But anyway, the company OMI apostrophe S OMI's products was, it said the company apparently made and sold jams, marmalades, jellies, fruits, whatever, and some alcoholic and non-alcoholic beverages. But they went out of business, even though they had trademark for their area of food under OMI's. Okay, so they went out of business. This company tried to buy the name, found out that they were making an offer apparently to not the owner of the name, because the owner had sold the trademark and the domain names to this other entity. Okay, well, the complainant in this case then reached out to a broker and said, can you help us try to acquire this name? We made an offer, but apparently not to the right person. The broker said, it is true, Media World Agency is the respondent in this case, and we're going to reach out to them. And they made an offer of, I believe, 20,000. It said, 20,000 euros to acquire it. And then the broker said they want a lot more than that. They made an offer of $5,000. The domain owner said we spent more than 20,000 euros to acquire it. So the chances of them selling it for less than that slim. Eventually, the complainant, they got a hold of this domain owner, and they got a number out of him and said they would consider an offer of at least 120,000 USD. All right. So I'm going to just leave some of the facts at that before I get into it more. David, I'll throw it to you first. Add some more facts to this case, if you will, and set it up so it's clear for the listeners to understand what's going on here.
Yeah, so this is the second try for this complainant. They tried first in 2025, and that complaint was rejected. And they, on the theory that there was no bad faith, but there was no response. So that was the default, but still rejected. So that was a good decision because the panelist just didn't close his eyes. Said it's a four-letter valuable domain name. Now the owner is Mr. Friedel, who owned this company, World Media World, and he didn't offer that $120,000. That was uh, something the broker said they would an offer they'd be at least considered. Said they would be willing to consider an offer of at least 120,000 USD, and that was in January 2025. But um, Media World, Mr. Friedel had already acquired the trademark. He owned the trademark from Omis. He bought it a couple of years earlier before the second attempt. So Omish from Italy, the crane company, tried to buy it in 2024, and then at some point, when did Media World actually acquire the trademark? Do you know that? Because that's kind of hard to pin down. The facts keep changing between the first case and the second case, so it's kind of mixed up. Did you hash that out?
Yeah. Yes, I have that, and that is it said between some point between March 27th, 2025 and April 11th, 2025. So right then, the respondent became the holder of the disputed domain name. They thought at that same time when he bought the domain name that he had acquired the trademark. It wasn't in this summary wasn't specific, but so right. Long story short is this new owner of the domain that's under dispute, omis.com, bought this company's trademark and along with the domain name when the complainant was originally reaching out to this domain owner. He thought it was the company, and then he finds out later, no, the company never owns it. They don't own it anymore. They were only had the rights to use this domain. But so getting to sum up this, the complainant was upset that they were, $120,000 would be a minimum offer. And then, so the complainant, I felt like it was, let's see. Jeff, do you have,
Yeah, do
what are
you want
your,
me to jump in?
go
So,
ahead.
I mean, essentially what it boils down to is the complainant thought that the change in ownership was sort of like a shell game, that because the each of the entities through which the um, trademark and domain name were transferred were all owned by the same person, this Helmet or something Friedel. And so the way that normally you're not supposed to refile a case, and new panels are very reluctant to review a decision, or yeah, review a matter that was decided by a previous panel. The only exceptions are if you could show that there's new material information that wasn't or couldn't have been available before, or there was a clear error or something like that. And so the way the complainant tried to get around it was to say, look, this whole ownership was so convoluted. We had to hire an investigator. It turns out that this one guy is behind it all. We didn't know that before. Now we do. And ultimately, the new panel said, look, you know, you still have the same problem you had at the beginning, which is when the domain was registered, you couldn't say that these names were registered in bad faith. There were these existing product lines that ultimately, maybe that company went bankrupt, but when they had the name, um, it was legitimate, and so there were legitimate rights, which is what they found in the first decision. And they said the complainant didn't provide enough evidence that the only reason the the trademark and the domain name were transferred to this new respondent was to avoid a UDRP, which is what its thesis was, I guess. The panel said, look, you didn't show that, and therefore there's no reason for us to, revisit this whole thing, that the respondent does have or did have at one point in time legitimate rights and certainly registered it in good faith. But yeah, this was a real complicated just ownership structure. I don't think the way that the decision was written was very easy to understand, but that's kind of what I got out of it.
Thanks. You cleared it up, Jeff. And so the domain is omis.com. This company, OMIS, which is the respondent company, OMI apostrophe S, okay, was around selling jellies and stuff. They apparently went out of business, but this one gentleman who owned Omi's Jelly, this company, transferred it to another company that he controlled, and then they did say, okay, so this is the right uh, respondent, but the complainant wanted to be clear, refiled their case. Anyway, the panel said, okay, we understand why you refiled. Long story short is you do have rights to file this case because you have a trademark under OMIS, even though you're an Italian company in a different business selling, big machinery. The second prong, and Jeff mentioned, was they tried to say this company has no legitimate reason to own this name or rights to use it. And the panel said they were a company in a different area. You can understand why they would want the name OMIS because they were OMIs as well. So they did have legitimate rights to it and used it in a bona fide way, even though they're not anymore. So the panelists then said, well, we don't even need to address the bad faith, registration of this because we already said you as the complainant weren't successful in the second prong of this. And then the panel did rule, no, there's no reverse domain name hijacking here. They didn't abuse the system. They spent a lot of money trying to figure out who really owned this and was, even though there could have been a case made for RDNH because if you looked in the Wayback Machine or this complainant sort of did know there was this company that was making other products on that name. But anyway, the panelists said, no, this wasn't an abuse of the system. They did spend money. And this was a 3-member panel. Warwick Rothney was the presiding panelist. There was 2 other panelists. So this was, the complaint was denied. The domain owner gets to keep the name. So that individual who did all this, like Jeff said, shell game, shuffling around ownership, don't know why he did it, but anyway, he gets to keep the name, and he did have rights to the name because, there was a company that was using it legitimately before, and this company was on the .net and just wanted it. All right, to stay on
Oh,
track.
one more
Good.
point about this case.
Yeah.
So in May 2024, Mr. Frido acquired the trademark from the liquidator for €1,000. So he bought the domain name separately from the trademark. So he bought Omi's trademark for €1,000, but it remains to be seen who actually he bought the domain name from for 20,000. So that's an interesting point. And the other point is that this trademark was registered to him personally, assigned to him personally, and registered his name personally, not his corporation, even though his corporation was owned by another corporation which he controlled, and he is the shareholder of the second corporation. That shell game still works for him, even though he owned the trademark personally. So that's interesting. So the corporate separateness was not an issue for these panelists. So those are some good points there. But he saved himself literally for just getting the trademark for €1,000. And the other thing is, there's a bunch of OMIS trademarks around the world, including the EU. So there's basically no claim of targeting on this complainant, and that's what they really can prove.
And it was the broker who said they spent €20,000, so they certainly wouldn't accept less than that. We don't know who said that to him. Was it Friedel? The gentleman said, I did spend it, and what proof did he have? But if you want to follow along, you can go to dnlshow.com/outline, and you can see the cases we're working on. So that was omis.com, a 4-letter that the domain owner successfully defended himself and kept the name. The next one is also a 4-letter, dmsl.com. And Interesting about this particular case, the complainant, Deepak Mining Solutions Limited, they're out of India. The domain that they are on for this particular area of their business, DMSL, is dmsl.dfpcl.com. So it's a really subdomain on their primary domain name, but they do. It is a full, complete business. Meaning, if you go to that dmsl.dfpcl.com, you'll see why they would want just to have dmsl.com. It's a large division of this company, and this just the DMSL subsidiary of this company, does big mines, tunnels, a lot of excavation work, but it's a pretty big company out of India. So they were the complainant in this case, and they filed it against Steve Ward, Stevie out of Canada. No, it sound like so this domain name DMSL, we call it a 4-letter with all premium letters, but it was the complainant incorporated in India in 2008, well-known big company, as I mentioned. The bigger company had been around since this 1979, but if I recall correctly, the domain was registered 1996. So it was registered way back in a long time ago. The complainant was upset. Sometimes you get these things confused. The complainant was upset because they just felt like that they bring up passive holding, and they felt like if you go to the website, and I'm going to check again, but I'm sure this was one where there was really pisses them off. Yeah, 403 error. When you go to, this is the exact type of scenario where the complainant hates it. He goes there. There's absolutely nothing on the website. He reaches out, can't get a hold of the respondent to try to buy the name. I don't know if he did. The respondent didn't reply in this case. Jeff, the summary was really, I don't know, short, not very good. I mean, compared to summaries that you write, well, you really get a feel for the case. This one, I don't know, what did you get out of this summary about the facts the complainant laid out, and then the no response?
Well, I mean, I think so. The complainant was claiming that the domain was being offered for sale, but it was really a broker. Well, the screenshot only showed register.com's brokerage service saying that we may be able to help you to buy this name. But, even if they had shown that, at the end of the day, um, you're right that the complainant tried to argue, well, they've been passively holding on to this since 1996. And they tried to argue that Telstra, which is that one case about passive holding, establishes that um, you know passive holding can be bad faith use. But what the panel comes back to, and I think the important point is, you still need bad faith registration. You know, which they couldn't show because the registration happened in 1996, way before the complainant had gotten any rights. So you don't even get to Telstra analysis of passive holding until you get past the I've established the domain name was registered in bad faith. Um, and there could not be registration in bad faith, as we said, because again, the domain was registered way after the I'm sorry, the domain was registered way before the trademark rights came into existence. So there was no way that this complainant could have won. And ultimately, at the end of the day, no surprise, but reverse domain name hijacking, because again, first of all, the complainant knew or should have known that they couldn't win. They admitted that the domain was registered in 1996. They admitted that they didn't exist until 2008. They admitted that their trademark filings, the complainant's trademark filings, were in 2025, but still tried to argue bad faith registration. And the panel said, look, you knew or certainly should have known that you couldn't succeed. And so RDNH.
Yep. So you mentioned RDNH, David.
Yeah. So, and the thing is here, when you file a UDRP complaint against this type of name that's from 1996, and you haven't started using the name till 2008, withdraw it right away, get your money back. That's what you can do. And that way, at least you get the information as who the registrant is. And then after that, you can negotiate, pay the price. If you're not willing to pay the price, that's all there is to it.
When there's a no response. So this case was decided by solo panelist Nick Gardner. I bring up Nick, he's also in the next case, but if you're not an ICA member, I joined the ICA for the fact that Nick is giving a talk. Nick Gardner is giving a talk. It's the annual Levine lecture at the end of this month. I think July 31st. I got to get the exact date, but anyway, I really look forward to it because I know a little bit about what he's going to say, and he's going to talk a lot about AI. And he's old school, very experienced, but has a lot of interesting comments about AI, and he's sort of open arms. And maybe I'm going to be wrong here, but I mean open arms to AI being used in many different capacities with relations to domain disputes. But anyway, I really look forward to hearing Nick's lecture, but he's a fantastic panelist and attorney, in my opinion. So he ruled that this is the exact kind of case that we love as a domain investor who has bought a 4-letter example way back in the day. I got a few dozen in my portfolio that I registered before 2004. And if I didn't respond in a case, this is exactly how I would like a panelist to decide that, okay, there's no reason for me to even look at whether the person has legitimate interest in it, the domain owner, because it clearly wasn't registered in bad faith. It was registered prior to the trademark. This domain owner didn't answer, but didn't need to. I'm going to rule in his favor, and I'm also going to rule RDNH, reverse domain name hijacking, because this complainant should have known better. That's it. So I like the idea of, of a panelist just being smart, beginning to end, with regards, don't make it more complicated than it is. So this was a reverse domain name hijacking, complaint denied, ruling by Nick Gardner. The domain DMSL gets to stay with the domain owner. And we're seeing cases like this more and more because complainants will make them spend the $1,500, or sometimes it's $1,300 and some change over at the forum, but they hope for a no response, and they hope that a panelist, for some reason, feels that well, we've seen it. Sometimes complaints are brought, Jeff, like we know with some recent things that you're working on. Complaints are brought later on, years later, and it doesn't mean that way back when the name was registered, it could have been registered in bad faith and used in bad faith. But anyway, it's conjunctive. It needs to be both. In
Yeah,
this
I
case,
mean,
there's no way. Go ahead.
I decided a case today that just came out that the domain was registered in 2005, but um, it clearly, wasn't used for a number of years. But then it started to be used. The only time it was used was in bad faith, and for that, because of the name itself, it was obvious that it was registered in bad faith. So, yeah, just because it was registered years ago doesn't mean that it's not bad faith, especially if the complainant had rights existing prior to the registration date. So, um, in this case, obviously, the registration date uh, of the domain name was before the trademark, so that's different.
Yeah, and next week we may, if once it's published, we'll talk about that case. I like it because it's not too late if you are a complainant that has been wronged. Somebody's cyber squatting on your name, and many times you don't go after it because they've done nothing with it. There's many big companies that people are constantly, basically registering names that seem obviously cyber squatting, possible trademark infringing. But when the person doesn't take any action on it, many times lawyers for the complainant says, okay, we're going to keep watching it, and as long as they don't do anything with it, we're not going to file cases against every domain that's registered, because these registrars let anything go, let anything get registered. And then finally, when someone makes a move and starts using it in bad faith, they still have rights. I like the idea more in regular law, where someone someone has a complaint. I like when there's no restrictions on their filing. Um, that if they want, if they were wrong back then and they file now, they can still, still recover. Or basically, they can still succeed in their case. Let's get to this last one and get out of here. So that was a complaint denied, reverse domain name hijacking. This last case, glide.ai. Okay, interesting name, sounds very generic and is. I mean, glide.ai. The domain owner here was represented by John Berryhill, and his name, Narendra, and I always mess up his last name, Jamire, but anyway, well-known domainer. I'm sure I met him one time because he's out here, and I think he's not far from me. And when we have meetups that are in our area, he and I'll both go. But anyway, um, I know there's a SoCal meetup coming here, I think in August. Depends on where it at. I'm just going to put it out there in Sherman Oaks. I can make it. Culver City, it's a coin flip. Downtown LA, no go. Okay, so this one, the domain glide.ai, is the domain name. This company, Glide, they're the company that offers like no code, low code. It says no code, low code software. So you can create your own software, and this company helps you. They're incorporated on the East Coast, but they're out here in California. They basically launched an AI product, and they want the name glide.ai. So they're on Glide Apps, GLIDEAPPS.com. And they launched this AI product, so they put that on glideapps.com/AI. So, it's obvious they want the domain glide.ai. So what they do, how I look at it, is complainants try to formulate a case that they think, all right, this is why this domain owner doesn't have rights to it, and how we're going to show that, the things that we need to show that they don't have legitimate rights to it and that they registered it in bad faith. This domain owner bought it in the aftermarket for $3,004 back in 2021. So he bought it in the aftermarket, owns a bunch of names, and that's sort of how John defended him by saying this is a domain investor, and we love these types of cases. And they were successful when someone says a pure domain investor has a lot of other domain names, and they listed several of them, several .ai names, and when this complainant reached out because it's a GoDaddy lander, an Afternic lander, and said, we'll offer $103,000. And they told the broker, we're hoping to get a response from this domain owner because we can start negotiations. And they didn't get a response from the domain owner. The domain owner was like, not giving you a response. I think they had a minimum. Before I just finish all the other facts, David, what can you add to this about the facts of this case, glide.ai? Then we'll go to you, Jeff, and then we'll sum it up and get
So
on
from a
now.
trademark point of view, Glide is actually owned by a company called Type something, and let's see exactly, it's TypeGuard, and they applied for the trademark in 2019. So that's before Narendra acquired the domain name, but they applied it for temporary use of non-downloadable software for tools for allowing users to create customized applications. But they didn't start getting in the AI field until 2023, 2 years after the domain was acquired by Narendra. And that makes the key difference in this case. The domain name itself was registered in 2017, which predates the trademark application. And I think even this company's incorporation potentially, because they say their first use was in 2018. So yeah, so Narendra had this name listed on GoDaddy with the GoDaddy lander. And inside, like, you don't get the price until you submit an offer. And so the minimum offer acceptable to him on his Afternic dashboard was $700,000. That's minimum. That's a starting point. And so these guys just started off at $103,750, as if that's meaningful. And that was like not worthy of response. What did you see in this, Jeff?
Yeah, I mean, first of all, there's lots of companies that, as you said, use the Glide trademark. Um, this complainant started in 2019. Um, Also, the respondent is as I think Todd, you said, is a domain investor represented by Berryhill, so you know it's going to be a good case. And this case recognized that, look, you there is a legitimate business, or being a domain investor is a legitimate business, and you're upset because the complainant's upset because it's going for $700,000 um, when they offered 103,000. That's tough. That's the market, right? Especially for descriptive, generic type words. And there is no um, there's no evidence of targeting, right? A panelist needs to ask themselves, was the respondent targeting this trademark owner, or did the domain investor buy a valuable dictionary word? And the panel decided, no, this is a dictionary word. There's no evidence that the respondent was targeting this particular glide. And this word glide is, you know, in line with some of the other AI names that this domain investor has. So no problems here. Um, and I think this was an RDNH as well. Yes. Um, it was almost like the complainant was arguing, look, we deserve this name more than the respondent does. And the panel's like, look, that's not what the UDRP is for. This isn't cyber squatting. Um, and I think this is the case where the complainant pointed out that the respondent was in a bunch of UDRP cases, but then failed to point out that the respondent won those cases, or most of those cases. So the panel criticized the complainant for, hiding the ball, essentially, hiding the fact that they respondent won these cases, and that's, that could be trying to trick the panel. So not a good thing to do.
This is a great example of a case why you would get, and I know you do this as well, hire John, hire Jeff, hire a domain lawyer that knows John answered, basically responded to all the allegations made by the complainant, but didn't overdo it, made sure though addressed everything. And when John said that's really deceptive, they're mentioning all these cases Narendra had been in before, didn't say that he had won these cases, won this case, won that case, and so on. And then the panelists also agreed that, well, John sort of thought, hey, this complainant offers 103,000. We were wondering if they were wanting to just get a response back saying, hey, we want 500,000. So then they could immediately say, well, that's way more than what was spent on this. We said maybe they knew that it was $3,000 spent on this domain name. The panel said, we're not in the business of appraising names and pricing domain names. And so this could be worth a lot. But I'd say this is a great example. If you have a valuable generic word type, like this, that many, many companies have, and you're on the end of a complaint like this, well, you need to get a professional to help you. But this is a good guideline to show, John showed, here's a lot of other generic words that Narendra has in .ai, and then like I said, he addressed every individual part of this, case that was, any allegations made by the complainant, but really, knock things out, one at a time. There was and John didn't even ask for reverse domain name hijacking here. I noticed, at least I didn't see that in the summary, and it looks like he didn't. And I noticed he doesn't do that quite often, but still gets the ruling reverse domain name hijacking, because the 3-member panel on this case, and I'm sure that was John's doing to recommend the 3-member panel, and then not asking for RDNH, but still get it because the panel, realized, okay, this person didn't have right. I mean, basically just wanted this domain so bad, came up with all sorts of allegations that could be refuted, and John did. It said it was well settled that renewing registration of a domain name does not constitute a new registration. John answered that, or put that in there, because the complainant said, hey, by the way, we know the name was registered before we were really active with, but when this guy got it, when the domain investor acquired it, he should have known. And once again, or I'm sorry, not just when he required it, but he renewed it in 2023 that they brought up. So bringing up all these little things like, hey, all these other cases, he renewed it in 2023. It was all bullshit, but John did address them, one at a time. And I like that, from the summary, didn't add a bunch of, extra stuff, only just loads up on the response of each allegation and just, disposes of these. Let's see, complainant's reference to, okay, yeah, that was about all the cases. So that was also a transfer. Go ahead.
One more point.
Yeah.
Yeah, so on the closing paragraph, it says complainant by its own characterization initiated the proceeding because it believed that it had more compelling use for the domain name than the respondent. And, I put this through AI when I saw the decision on Friday. And you know what? Brock says that's classic indication of narcissistic behavior, that they feel that they're elevating themselves above others. And as such, they believe they can take from others what they want without actually having to pay for it. I find that criminal. Brock didn't want to believe that, but that is like theft. In my book, trying to steal a name through a UDRP complaint is like trying to leverage the IP bundle of rights beyond its purpose, and that is wrong. It's theft. So, they think they can sometimes litigate you to the end and win, but that's evil.
Eva, when you said that, elevate yourself above others, that hit close to home for me. Okay, I'm just kidding. I'm not a narcissist. I can't even spell it. Hey, all right. Well, thanks for being here. Really appreciate it. So those were our 3 cases today. Congratulations, domain investors. They succeeded in all 3 cases. Next week, I'm going to have cases where, I already have a couple in mind, but it's transfers. And those are the ones I like, because usually if it's one where a domain investor feels he has rights, but it's transferred away from him, gets everybody a little, high strung. But so please join us next week, Tuesday, noon Pacific. We're trying to stay on a really tight schedule. So when you're listening on replay, whether it's on YouTube, here on X, or Spotify or Apple, it's not dragged out. You want something dragged out? Well, I can tell you, go to Ish Millie's room. I just said to you, Ish. I see you here. On Saturdays, it's fun, but same here, domain DNX show. So you want things dragged out, you want to talk domain investing, we do it on Thursdays, 10 a.m. Pacific, 1 p.m. Eastern. We got a big, now that the World Cup's over, we got, only domain stuff to talk about. So please join us on Thursday. Join Ish's room on Saturday. That way, anything goes, open stage, everybody. We want to hear from everybody. So really look forward to having a domain investing chat on Thursday. Until then, take care of yourself. We're done for the day.